When does an office romance become a legal problem? When it creates a hostile work environment or becomes sexual harassment? I'm Dan Ringer, and we'll talk about sex in the workplace right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
Office romances are not uncommon, but sometimes they cause very serious problems. My guests are attorneys Eric Kinder and Susan Denneker. Eric, Susan, thank you for being with us. I want to put this in the context of David Letterman's recent unpleasantness. What was the first thought that went through your mind when you heard about his problems?
Well, I was actually watching the confession. I happened to be up that hour, and I'm thinking, I bet my phone is going to ring because that's going to strike way too close to home for someone when they're watching this show. And they're going to want to know how to address this.
We should mention, Susan and Eric, you both practice employment law in large part of your practice. Susan, what did you think when you saw all this?
I was surprised at how lightly he chose to handle it, that he chose to handle it in that format, given the seriousness, apparently, of the situation. And I was a little bit surprised by the ongoing media attention for the following weeks, just because it got so much media attention without any of the actual females involved in it coming forward.
We probably ought to summarize what happened and what Mr. Letterman's unpleasantness was. Apparently, a former CBS television producer went to him and said, I have written a book or a screenplay or a treatment for those, and I'm going to sell them to whoever wants them, or I'll sell them to you and won't write the book because here's what it's about. You've been having sex with your employees, and I'm going to talk all about that, and you're likely to be embarrassed. Now, that may or may not be a crime. There's some discussion about whether it is, but David Letterman then went on his late-night CBS show and confessed to having sexual relations with some of the women he works with. Not a woman he works with, not a couple of the women he works with, some of the women he works with. And you folks are employment law lawyers. I know what first went through my mind when I saw it. This is where the word expletive deleted flashes on the screen, because I saw that and I thought, oh Lord, no, this is not good. And I turned to my wife and I said, we're going to hear a lot about this.
Yes, absolutely. And this is why in my practice, when I'm talking to clients of the firm, I am constantly reminding them of the need to create a separation. I mean, I'm not trying to create a robotic workforce where individuals aren't able to engage one another comfortably, but you need to have some common sense boundaries in the workplace, especially when you're dealing with, as you have in the Letterman case, the boss of all bosses in the workplace and people who are working under him.
Well, there are studies that indicate that most people find spouses, boyfriends, girlfriends in the workplace or in school, in the places where you are frequently with other people. So if you can't form romantic relationships with the people you work with, we're going to be putting severe constraints on the way people live their lives and have lived their lives. But there are some companies that have policies basically that say one member of your family can work here. If you're going to marry a coworker, then one of you has to leave, or if you're going to form an intimate relationship, one of you has to leave. That's a very high, very tough standard, but it avoids a lot of problems.
They're tough decisions, and you recognize something that's really important is that people do meet in the workplace all of the time, and they do engage in intimate relationships, and I don't think that that's ever going to go away. Something that I think has made sexual harassment issues a little bit more difficult are some of the more casual communications we have with people through email and texting, and I think it's opened up the door to so many more areas in which harassment can occur, or at least accusations of harassment can occur.
So what kind of text or emails are you referring to?
Well, sometimes it's between coworkers at work. You know, we're all familiar with, you know, joking emails that we get that sometimes are of an inappropriate nature, if it's just at a professional setting, and all of us have gotten those and laughed at them maybe and forwarded them on, but when you think about it in a professional setting, that's concerning as to how sometimes people are going to perceive that and whether it's inappropriate. Sometimes it's just people emailing back and forth things that are inappropriate, and it happens not only in the workplace, but outside of the workplace. And I think that that's the more difficult issue is we have, laws that are pretty clear about what you can and can't do in the workplace, but what happens when you go home and you get an email at home from your boss, or you get a text. We get these calls all the time that this person texted me and it was inappropriate, or I was uncomfortable by it, or, well, we texted back and forth for a long time, but after so many weeks, I felt that he crossed the line. So I think those are the difficult boundaries that we're starting to see in the employment context is what happens when you leave work, but the relationship with you have with this person and that you've developed is through the working relationship, but goes to the boundaries outside when you get an email or a text or whatever.
And sometimes things that you do as a matter of course, or regularly at least, take on a different aspect when they're done somewhere else or in a slightly different context. Many years ago now, I remember it because I've been around many years ago, Dan Aykroyd and Jane Curtin did a routine on Saturday Night Live. It was their standard news segment.
Yeah.
And Jane would say something. It was usually a point-counterpoint type discussion. And Jane Curtin would say something, and Dan Aykroyd would open his response with the phrase, "Jane, you ignorant slut." Now, if everybody understands that's a joke, that's fine and that works. It's when it becomes so common and it becomes so much a part of the way you react to things that I turn around and say, "Susan, you ignorant slut," and Susan's not in on the joke. Then that goes badly.
And it's interesting for me because I have a first-hand experience with literally that joke.
Now, you don't need to make any confessions here.
This would have been a friend of mine. But this occurred in law school, and a classmate in the middle of the standard give and take of a law school class responded to a female classmate literally with her name, "You ignorant slut." And we had to explain then to the dean, because this student didn't know Saturday Night Live from the 1970s, what was going on, and that no, it was not meant as a demeaning comment, but meant to be part of humorous give and take. But the problem that you just raised is the issue of context. And the issue in our world and in the world of people that are dealing with HR about trying to figure out what was the context of the communication and whether or not it crosses a line.
You use the phrase or the letters HR. HR stands for human relations, and that's really where all of this falls in the context of the business place or the employment relationship. For whatever reason, that's been assigned to a department in most companies that have departments called human relations.
Well, and to piggyback on that, not only do you need to know the context, but the issue it could be where you have somebody that frankly wasn't made uncomfortable. To be actionable, sexual harassment is supposed to be unwelcome. That's something that, is an element that you need to prove is that it's unwelcome. So if it's something that you've brought on yourself or you've participated in, then it really isn't unwelcome. But you may have a situation where it starts out as bantering back and forth that you're comfortable with and crosses a line to something that a person becomes uncomfortable with. Or sometimes we see this situation where, frankly, it probably wasn't unwelcome, but the person becomes unhappy with something down the road and then can point back to something that, taken out of context, sounds very inappropriate.
I'm sorry, I was going to say one thing I think is very important to keep in mind is that it's supposed to be a hostile work environment that is both objective and subjective. And so there's going to have to meet both prongs of that test. It's going to have to be an action, a comment, an email, a picture that not only truly offends the person involved, but also would be considered offensive by a reasonable person. And so the mores of the workplace aren't guided by the most sensitive person in the building.
But the David Letterman situation is a good example because, frankly, we don't have enough information at this point to know whether sexual harassment occurred in that workplace. I thought it was interesting. Now came out with a statement very soon after this scandal came out and described the workplace as toxic. And I thought, well, maybe it was, but frankly, we hadn't heard from any of the women at that point to say that that was true. So we don't know that. But what's more important is that whether you win a sexual harassment case at the end of the day, whether even a case is brought against David Letterman is one thing, but it looks bad. It's embarrassing for people. I mean, David Letterman's obviously a public figure, but even for Joe Schmo, who's in an office, these allegations are embarrassing. And something you said that was maybe joking, and was only intended to be heard by a couple people, when somebody puts it out of context and you just hear that you said something that was inappropriate, it's embarrassing.
Well, I always caution people to understand that words take on different meanings, whether you read them in print or you hear somebody say them. And usually I use a simple 3-word statement like, I love you. In print, that's a declaration of an emotional relationship or a feeling. But if you say it, it could be, I love you, I love you, I love you, or I love you. Now, all of those are different meanings. You take the words, I killed him, and if you say it the wrong way, you go to prison. And if you say it the right way, it's a defense.
Right. And that's a very good point, because you can't get inflection, you can't get intonation in an email or a written communication. There's no way to determine whether a statement is sarcastic or not. And I hear that numerous times about, you see a statement in an email, like you said, I love you, I'd love to go to bed with you, or things that are, more degrading than that. And the comment is, oh, I didn't mean that. I'm looking at it here in the paper. You wrote those words. Yes, but I didn't mean it. It was a joke. I meant it sarcastically. Email is about as permanent a form of communication, except perhaps engraving with a chisel on rock. People that know what they're doing can dig up email communications through, years of attempts to erase. And I think a lot of people forget that. It's that comment, that statement's going to be around forever.
Well, the objective-subjective standards are really, really important. If I walk up to you, Susan, and there's a bit of lint on your shoulder and I remove that lint, that may be an unwanted touching. It's certainly a touching. I put my hand on your shoulder, and some people would take great offense at that.
Right.
Other people would say, thank you for removing the lint from my shoulder. So I guess the test then becomes, what does Eric think of it as the objective person standing there seeing what happened?
Well, thank you. I appreciate the compliment.
Well, I'm trying to be nice. You've already made this terrible confession. But when we deal with words like objective and subjective, it's like the word reasonable. Lawyers hate the word reasonable because it's an invitation to a lawsuit. Because automatically, when you start defining things in terms of being reasonable, being objective, being subjective, you're asking for people's opinions. And people's opinions can go badly wrong sometimes over seemingly innocent things. So in Letterman's case, as you said, he was the boss, the big boss, the chief. There are different rules for people who are superior and who are subordinate.
Oh, there absolutely are. And because there are different forms of sexual harassment, and without breaking into a Latin class, there is what they call the quid pro quo harassment or discrimination, which is the sleep with me, go out with me, and I will give you a raise, a bonus, a promotion. And there's certainly that flavor from what we know now in the Letterman case. As Susan said, I certainly don't know what occurred in the workplace. I don't have a firm opinion one way or the other. But there is that flavor when you start talking about the boss of bosses in the workplace, the president, the CEO, having a romantic affair with someone in the workplace. There's always that concern.
Yeah, and I think, when somebody's in a higher position, it lends itself to the argument that maybe something wasn't consensual because somebody felt that they had pressure on them to engage in certain activities because this was the boss. And in David Letterman's case, he's really going to feel that heat because he was an important figure and, he held a lot of influence. And so I think it makes it easier to make an argument that it wasn't consensual. Now, we don't know that, obviously, in that circumstance. And liability's different in the employment area based upon whether the harassment was done by a simple coworker or by a supervisor. Employers are strictly liable for harassment by a supervisor, but they have to have knowledge. They have to be in a situation where they knew of harassment or should have known harassment in the coworker setting.
Strict liability means that if it happens, you pay for it. Just the fact that it happened is enough. And that's strict liability. If you drop a safe on a road runner as he's going in front of your house, you're probably strictly liable for that if that was your safe and you knew that the road runner was going to be coming by. And so when the chief does something to an employee, the company is responsible for what the chief has done. In this context, there's strict liability there.
Right.
We don't know what happened, but the initial reaction I had was somebody is going to come forward in a week or 2 or 3 and say, I worked there and I saw this and I wasn't treated fairly because I wasn't having a relationship with him. And sure enough, a writer for Vanity Fair stepped up a couple or 3 weeks later, a woman named Nell Scoville, and said that she was so uncomfortable working for Letterman's company that she left. Now, she said she didn't want to sue anybody, and the way she described the circumstances, she probably couldn't have anyway. But that's one of the things you worry about, is the way the relationship, voluntary or not, affects other people.
Well, absolutely. And I think that it certainly, this lady that came forward claimed that it was a very uncomfortable situation, and that while she didn't personally feel that she was subjected to harassment, or, I think she said that she didn't feel like David Letterman had ever hit on her or said anything appropriate to her, that she felt that other people were rising within the organization because they were engaging in relationships with him. And certainly, whether or not she has an actionable claim is one issue, and I don't think she probably would, but it makes for a difficult work environment, and a work environment that other people aren't going to want to work in.
And it wouldn't take much to tweak those facts and get a more compelling case where perhaps she can point to the fact that the only women who ever advanced in the company were women who had romantic affairs with David Letterman. If that were true, and I don't know that it is, you would certainly have, I think, a more compelling case to at least lengthen the lawsuit. And as I like to often tell clients, there's one thing about you win the case in the end, but at what cost? I mean, you have had people be deposed, you've gone through the legal process, you have paid your attorneys, and while I enjoy being paid, it's not generally the most productive thing for a business.
Yeah.
And so you want to try to avoid that. And so, yes, perhaps, as Susan says, I think absolutely correctly, there's probably a very strong defense for David, even under the circumstances I detailed. It's expensive to win that.
Well, the Vanity Fair author said that his girlfriend of the moment, because if a lawyer was designing David Letterman's confession, he wouldn't have designed that one. Right. He came out and he said, I've had relationships with a number of the women I've worked with, and the Vanity Fair author just pointed apparently to one, or the most recent one, or the one that he had indicated most strongly he had been seeing, and said that she had risen to more responsible positions. She had gotten on-air time as an extra, I guess, or a background person on his show, which presumably was something people who are in television like to get. I certainly enjoy getting it. And you do too. Sure. Let's be honest about it. So she was saying, yes, his girlfriend, his paramour, got favorable treatment. But the test is not whether she got favorable treatment, but whether she got favorable treatment instead of others getting that treatment on the basis of sex. And that can be awfully hard to prove.
That would be very difficult to prove. But that doesn't, again, prevent someone from bringing the lawsuit and dragging you through 6 months of the legal process to vindicate your rights, which is why, to go back to what we said earlier, a real common sense approach about managing internal affairs, romantic affairs in the workplace, saves a lot of aggravation.
So, Susan, what would you recommend to a company to avoid these problems? What can they do?
Well, the first thing they need to do is get a policy in place that outlines, first, that harassment of any type, based on any type of prohibited conduct, including sexual harassment, isn't going to be tolerated, and putting an appropriate complaint procedure in place so that there's somewhere to go when you have a complaint. And it also needs to contain something that allows you to go around the person that may be harassing you. And if you've got to go to your supervisor and your supervisor's harassing you to make the complaint, you're not going to do it. So that needs to be in there. Secondly, you need to provide training on it. You need to go out and train your supervisors and your HR people, if you have those people in place, on the policy, the fact that it's not going to be tolerated. And you need to address the issues when they arise. If you find out that somebody's made a complaint, or you just become aware that there's a possibility that there's inappropriate conduct going on, you need to do an investigation, and if you find out that somebody's acted inappropriately, you need to take appropriate disciplinary action. You got to show we take this seriously, and we're going to do something about it if we find out people are engaging in wrongdoing.
Eric, do you have any thoughts on that?
Well, my biggest concern when I work with employers in the state of West Virginia is that they may have a policy in place, but it's forgotten about. And what Susan had said, I think, is very important. You have to show that you take it seriously. And one of the best ways to do that is to actually engage in real training of your employees on what is sexual harassment, what is workplace harassment. Let's broaden it to the concept that you aren't supposed to be treating people because of their race, because of their religion. And my experience has been people understand that. I mean, nobody in their right mind is thinking that it is acceptable to use the N-word in the workplace, but they may not fully understand, well, what do you mean that the joke that I sent on email is a problem? That was just me and my friend Tom. You know, nobody else saw that. Well, sure, but the computers are available. Anybody could have seen the pictures that you sent, the joke that you sent. You're not supposed to engage in that sort of workplace behavior. And I'm sure Susan has the same experience. I've just sort of seen the light bulb come on over people's heads of, oh, okay, I won't do that anymore.
Yeah, a lot of times we call it heightening awareness or increasing sensitivity to things. Until somebody points out that there's a problem, we tend to miss it. We tend to be naive or just sometimes dumb.
Or we don't see it as a problem, like Eric said, because we didn't mean any harm by it, and we're joking at the time. And, you know, really, I think the employers that are the best off are those that kind of have zero tolerance policies. In other words, we're not going to joke about these types of issues at all because the harm that can come out of it is too serious. And so we're not going to, you know, act like that. And certainly I've worked for people that, you know, I couldn't ever tell you have ever said anything inappropriate because that's the way they conduct themselves. Maybe it's because we're lawyers and we see too much of this. But, you know, joking aside, Eric and I have just seen case after case after case where somebody sent an email or told a joke or made a comment, maybe that they intended as a compliment, but that when it's taken out of context and it's in black and white, it suddenly doesn't look good anymore. And cases are built around those very comments.
Yeah, I often talk about the concept of the golden rule. I mean, we all have that from our experience in Sunday school, and it applies in the workplace. I mean, don't say anything to anybody that you wouldn't want turned around and said to you. And a lot of folks sort of think through that and go, all right, it may not work 100% of the time because you may have the truly insensitive clod in the workplace, but most folks seem to understand, okay, I would probably be offended if somebody was making a joke about the way I looked or touched me in that way. I shouldn't do it.
There are situations that just seem to fall out of the sky, though, and we frequently hear them in terms of people on television or on the radio. Most recently, a sportscaster was talking about a Puerto Rican football player, I think it was, and somebody said, well, where is he? He's not on the field, or he's not doing this, that, and the other thing. And the sportscaster said, he's probably out having a taco. And the Hispanic community went nuts over that because the guy's name was a readily recognizable Hispanic name. I don't remember what it was, but something like Martinez or Rodriguez that people tend to recognize. And he was from Puerto Rico, where apparently tacos are not part of the regular cuisine, but it was considered to be a very offensive comment for him to make. In the workplace, you're more likely to see something like the scantily clad calendar from the tool supplier hanging on the workshop wall, to which some people would take great exception and might voice complaint. So we just have a couple minutes left. If you're the employee, what do you do when you find something offensive or something's happening that you take exception to?
Well, I think the first thing you have to do is not only talk to the person that is engaging in this offensive conduct, because oftentimes a quick comment diffuses the situation before it blows completely out of control. You then have to take matters into your own hands and use, hopefully, the well-drafted reporting policy in the workplace and make a report. And you want to do that because you also want to protect your colleagues. I mean, you want a good place to work. You want everybody on the team to feel like they're working together and pulling together. You're looking out for each other in that way.
One of the biggest reasons that lawsuits are filed is that people fail to communicate with each other. It sounds like a Paul Newman movie or something. They have a failure to communicate. But that's what happens. If people don't talk. If you're offended by something in the workplace, go to your supervisor and simply say that. You're protected from retaliation, and you might actually get whatever it is that's bothering you resolved. Susan Denneker, Eric Kinder, thank you very much for being with us.
Thank you.
A pleasure.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening.
If you want to know if you need a lawyer, you can discuss your problems with a lawyer by calling the West Virginia State Bar Helpline, toll-free, Tuesday evenings from 6 to 8 at 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics, information on how to obtain copies of the programs, and additional information about this show's topic. You'll also find a list of legal resources that can help you answer your legal questions. If you'd like to recommend this program to a friend, you'll also find video of this program on thelawworks.org. If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
From West Virginia Public Broadcasting.